Let's talk about U.S. versus Nora and some follow-up questions. That's that case involving a surround and call out on Nora, and it lasted 30 minutes, and the Ninth Circuit said no go. Hey guys, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you into the Roadside Chat, broadcasting from my lowly hotel room in McKinney, Texas. McKinney is off the hook, by the way. So I have some time to kill, got here a little early. Usually I fly in late, so that gives me more time home, but I'm glad that I actually have some extra time so I can sit down and record a few videos. Let's talk about Nora. So I made a video, if you follow my channel, I made a video recently on U.S. versus Nora. What basically happened there is officers in LA, I think, but Southern California, they saw Nora and two of his buddies in front of his house talking. They're all talking. They want to make a consensual contact, so they go up to, they get out, they contact the three guys, they start talking to them, maybe for 30 seconds or so, and then Nora just abruptly turns around and starts walking into his home. Well, that's when they noticed that Nora, throughout this whole time, he was hiding a gun. He was probably showing it off to either sell or he just purchased it, whatever it was, but he was holding this gun, and he started walking to his house. They told him to stop, freeze, hold it right there. Nora wasn't going to stop. He just walks right into his house, shuts the door, and we go from there. Now, gun in California means you're going to prison for the rest of your life, I guess, right? Because they see that gun and they automatically, of course, I'm not saying that they're not right about Nora. Nora's probably not a good dude, but of course, this was a crime. In many states, having a gun, even though oddly, under these circumstances, it would not necessarily be a crime, but the court did acknowledge that under California law, they had PC, that he had a loaded handgun in public. I don't think they had x-ray vision to see that it was loaded, but there probably would be a presumption that having a gun out of of a holster, whatever, or waistband would be loaded. I'm totally fine with that if that's what the law is. If you have the gun out, it's probably a loaded gun in public, especially if it's not in a container and so forth. Okay, now we have to go to that SACO, the surround and call out. The Ninth Circuit said bullhorning him out of the home for 30 minutes was not lawful because it basically was an in-home arrest. I want you to think about it. When a person is bullhorned, ordered out of their home, are they submitting to a show of authority by the government? The answer is yes. They did not come out on their own. Clearly, if they want to come out on their own, you wouldn't need to bullhorn them out, right? So when they came out, was that a submission under a show of authority? Yes. Where did that submission occur? In the home, right? So when they decide to come out of their home, that was a submission of authority, and so therefore you have an in-home arrest. That's a problem, because if you're going to have a constructively an in-home arrest, legally, it's the same thing as you going in there and putting hands on this guy. Well, from a case from 1980, Payton versus New York, that you cannot enter a home with nothing more than probable cause, even a violent felony like a murder, which was what Payton was accused of. You cannot enter that home just to make a quote-unquote routine felony arrest. Okay. With that background in mind, let's go to our officer, who is also from California. He says, what if you have a search warrant for the location but not an arrest warrant for someone inside? Do the same rules in Nora apply? Can you order everybody out? The answer is absolutely. Without question. Whether you want to enter that home and execute that search warrant, or you just want to be safe about it and surround the whole premises, and with the Bearcat and the cops in the green pajamas with their AR-15 slung, you can absolutely order them out. Now, you can also detain everybody in the home that has a nexus with the home, right? We don't detain UPS. We don't detain the plumber who has nothing to do with the home. They're just there visiting or dropping off packages. Not when I say visiting, I mean I shouldn't say that, because visitors of the occupants can be detained. But I'm talking about visitors who are just there for commercial purposes, right? Amazon, the plumber, and UPS. Okay, that's Michigan versus Summers. In fact, these are actually known as Summers detentions. So you can, if you have a search warrant for whatever, you can call these people out. You're good to go. All right, the next question is, the cop says, what if you see a group of gang members, but they run into the house when you attempt to contact them? You recognize one of them to be on probation with a search and seizure condition, so they have a Fourth Amendment waiver. It's not his house, though. It's his friend's house. Can you call him out, and can you then search the house based on those conditions? All right. So that's a little bit tougher, right? We know this is for California folks. California overall has the best, and has the best, search and seizure provisions for probationers and parolees in the country. You'd be surprised at that, because a lot of people are like, oh my God, California, they're the worst. They're the worst in a lot of ways, right? They're worst on their property taxes, and they're worst on their laws, right? And they're worst on the leniency that they give their criminals. But they are not the worst when it comes to search and seizure laws. In fact, riddle me this, they're actually the best. Why? Mainly because of their constitutional provision that they passed in 1984, called the Truth and Evidence Act. Basically, the voters in California voted to amend the Constitution to require that all state courts comply with the U.S. Constitution when it comes to constitutional provisions, not only Fourth Amendment, but also the Fifth Amendment. So when you see the California courts changing the rules of the game and saying, oh, well, we have to treat juveniles like this, and we can't get confessions without their attorney present and so forth. Well, strictly speaking, that's not lawful, right? Because they're going against the Truth and Evidence Act, even though, of course, my cops in California comply with it because that's what the law is, and they don't want to break the law. But under evidence rules, they don't have, the courts do not have to comply with that restrictive law. Going back to the Fourth Amendment and search and seizure provisions, the California legislature has a very broad statutory scheme, including constitutionally, where you don't need any kind of reasonable suspicion or reason to search somebody on paper. You can search their person, their car, and anything that they have access to, but really common authority over. Do they have common authority? Okay. Going back to the friend's house. No, we're not tossing this person's house just because they invited somebody in their search conditions. That would be a firestorm, in my opinion, of case law. I mean, I don't know. Look at it from your point of view. You have a cousin, who was on supervised release. He's visiting you. He's sitting on your couch. The cops knock on your door. You answer. Who is it? Hey, it's your local police department. And they see your cousin sitting on your couch, eating ice cream. And they're like, hey, that's good news for us. He's on supervised release. Move out of the way. We're going to search your house. You would be up in arms. I know that you would, because cops are the first one to complain when their rights are violated. They'll complain the most. And I'm right on this, right? And so this ain't going to work. Your cousin does not have common authority over your house just because they came by and visited. I will tell you though, the cars, when it comes to traffic stops, your California courts are pretty lenient on searching those areas where they could access, and put weapons and put drugs and so forth in the vehicle. They don't use the phrase common authority. I wish that they would. I think that's what the law requires, but there is a case out there, in California that simply requires just access. That case is People versus Maxwell, December 11th, 2020, from the California Court of Appeals. And that is, again, a court, the way that the guy was on supervised release, he was a passenger in a vehicle. They searched somebody else's property that was not Maxwell's. They found evidence against Maxwell. That's why his name is in the title of the case. And Maxwell said there was an unlawful search. The court said no, because Maxwell had access. Again, what we teach at Blue to Gold is common authority, but also, I understand that they're going to find it probably a little easier when it comes to cars, because they may have legitimate access to all these areas. That's fine. I don't have a lot of heartburn over it, but we cannot use that same loose, mushy, easy to get over, hurdle, low hurdle standard for homes, right? The home is the most protected area in the Constitution. And I am certainly not going to tell you that I think that you can search a home with nothing more than a visitor who's on a supervised release. They need to live there. They need to have unfettered access to that home. They need to have something more than that, right? Okay, that's what I'm going to teach you, so I hope that helps. If you like what we're doing around here, please do me a favor. Hit the like button. That helps YouTube, the YouTube algorithm, say, you know what? people like me will probably like a video like this, right? So they kind of know people, like-minded people, right? The other one is commenting really does help, because whether you agree with me, disagree with me, have a question, feedback, and finally share with your friends. Let other people see this too, because I'm trying to keep the conversation going. You cannot be one and done with search and seizure. You know that, and I know that. This is all hire to retire. You are never going to be done with search and seizure until you hang up the saddle. All right? And with that, my friends, stay safe and make good case law.